This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer. Today's guest, attorney Merry Campbell, is the Employment and Labor Law and Corporate Investigations Chair at Shulman Rogers. She is frequently quoted and well-published by highly respected industry and news outlets and has been honored as a top attorney by Bethesda Magazine. Ms. Campbell holds a JD from Harvard. Ms. Campbell, thank you so much for joining me here today on Engaging Experts.
Glad to be here. Thanks so much for inviting me.
Of course, let's jump into it. So for today's show, I'd like to focus on independent contractors, an area in which you have considerable expertise. So let's talk a little bit about independent contractor basics. What does it mean legally to be classified as an independent contractor versus an employee?
That's a pretty broad question. I think the best way to think about it is for most employers, when you have a worker coming to provide services for you, the default understanding from the government's perspective and from a lot of plaintiff lawyers' perspective is that every worker is a W-2 employee and should be compensated as such. And W-2 employees often have, particular protections. The anti-discrimination laws come to mind, other protections that are legally based. They also have certain benefits. Those can be statutory, for example, things like unemployment, workers' comp, and they can also be elective, things like some of your insurance benefits. Healthcare kind of falls quasi-statutory and quasi choose your own adventure. But sick leave also could be sometimes statutory. And then things like vacation and all the other goodies you provide to your employees, your regular W-2 employees. If someone comes to you and wants to be a contractor, a 1099, if you in the typical situation, you have to overcome the presumption. So most employers understand that their workers have to be W-2 employees, and you have to fit certain legal criteria in order to qualify as a 1099 contractor. There are certainly some advantages, some disadvantages, and some advantages to being a 1099 contractor. You have a little more freedom and control over your work. You can negotiate who owns the work product in some circumstances. Similarly, there's some tax differences. That's not always an advantage, but it's a tax difference, a different treatment in terms of, potential, your equipment, your travel, things like that might be taxed differently. And because you are not entitled to some of these benefits, if you're working as a 1099, sometimes the compensation rate is higher to reflect, the value of the service less these sort of extra goodies that you might get if you were in fact a W-2 employee.
Does a lot of this depend on venue, what state you live in, or is a lot of this kind of more at the federal level? How does this affect expert witnesses who live in a variety of different locations across this country?
Great question. And these are the kind of questions that keep me employed as a lawyer. There's no straight answer. They are what my husband calls DIMLR, which is a series of laws at both the federal and state level that are similar but different. Even at the federal level, there are different tests depending on which agency or department is looking at the 1099 status, the independent contractor status. So Department of Labor has a slightly different test than the IRS. And there are scenarios where you can qualify as an independent contractor under one test, but for one agency, but not the other test, not the other agency. And then again, there are different tests at the state and local level. So because the default understanding is that you are a W-2 employee, where this will often come up is when someone files for unemployment following the end of the working relationship. Remember, if you are a 1099 contractor, you're not entitled to unemployment, but that also means that your employer or the entity you've been contracting with has not been paying your unemployment taxes, has not been making the employer contributions. In that scenario, it is not uncommon for the state level unemployment agency to want to take a closer look at that relationship to determine whether or not you were properly classified as a 1099 or should have been a W-2, and those required contributions should have been made.
Let's talk a little bit about the intersection of independent contractors and expert witnesses. To what extent does this affect experts? Are a lot of experts themselves independent contractors?
I've seen it. I work with several organizations that work with independent excuse me, that work with expert witnesses, and I've seen them characterized under both frameworks, under, in some circumstances under W-2 and in some circumstances under 1099. In some industries, when clients come to me, I strongly encourage them to move away from the 1099 model because it's not one that really fits the reality. I would say expert witnesses is one of those rare breeds where, in fact, we can make 1099 relationships work. That said, it really depends on the nature of the relationship. So if the organization is views itself as a little bit more of a matchmaker than an employer. So they are the go-between between the law firms or the various organizations that might need an expert witness and do the cultivation of various resumes, does a review to make sure that the expert is who they say they are, has the background that they say they have, et cetera, et cetera.
So, like an expert witness referral agency, for instance?
Correct. If the relationship, the entity that for whom you're providing the services, I'm trying to avoid saying the employer, but if the entity for whom you're providing the services is really more like that agency or matchmaker role, then that is one where the 1099 relationship can be justified. One of the keys there is that the contractor is supposed to be able to control the economics of the situation. So the relationship has to be one where the contractor has an opportunity to, for example, and these are all just examples, there's no one right or wrong answer, but they might have the opportunity to accept or reject work, to set their own rate, to do it on a project basis instead of an hourly basis. All of these things are factors that support the notion that they're an independent contractor. And similarly, we'd like to see that they have the opportunity to provide those services to multiple different agencies, not just to one. Any of these things, we can just no one of these is dispositive. So if in fact, we are not comfortable with an answer on one of these factors, but the rest of them all look good for 1099 status, then we might get some comfort there. But these are all various things that we can look at to support and justify the 1099 relationship.
I'd like to talk a little bit about the agreement between the parties here, and go through just some of the specific kinds of terms, conditions, negotiating points that independent contractors go through. And I'd like to start with which party drafts the contract in the first place. Should the expert prefer their own firm's agreement as a starting point? Should they go with whatever the attorney gives them? What do you recommend?
So there's like an old lawyer saying that, to the drafter goes the spoils. So a lot of times the party with more control here would prefer to draft the document. That's usually going to be the entity for whom you're providing the services, but not always. So if you have particular clauses, particular approaches that are really important to you, I think it's important that you take a look at those, maybe hire your own lawyer to come up with language that passes legal scrutiny, and at minimum be in a position to share those select provisions with the entity you're working with, if not coming up with an entire agreement of your own drafting.
What are some of those key provisions? What are some of the most important points that experts should be familiar with and thoroughly read before signing anything?
So, like everyone who provides services, you want to be paid, right? So when do you have to invoice? How often are you being paid? What is considered product for which you will be paid? Are you paid by the hour? Are you paid by the work product? As an expert witness, you want to be very careful that the language does not say that you're paid for your opinion. A good lawyer will work pretty hard to destroy your credibility if that's how you're being paid, but you certainly can be paid for your time. You can be paid for the report itself, for the project. But those are things you want to think through. And sometimes either the entity you're working for or the the law firm or the end user might have some thoughts on this as well. But these are all things to pay attention to. You want to think about how the contract can be terminated and whether you get partial payment and in what amounts and how is that calculated. And then beyond that, you want to think about things like indemnification. You want to be clear about what expenses are reimbursed. And, if travel is required, things like that, things that can be fairly costly. Often if I'm working with the entity for whom you're providing services, I'm advising them not to pay for your travel because that looks more like a W-2 employee, but maybe you can negotiate a higher rate to encompass those travel rates. And so you're fairly compensated for the work you're providing without it falling into the trap of looking more like a W-2 relationship.
You mentioned termination. How should termination clauses be structured?
One, they want to make sure that they can get out of the relationship, right? That they can end, that it's a mutual termination. And, push comes to shove, you're usually able to get out of that relationship, but you also want to be fairly compensated for the work that you've provided. So you want to think about prorated compensation, maybe think about if you're doing this on a project basis, milestones for which you'll be compensated. If it's hourly, that you'll be paid a prorated rated amount. We talked a little bit about timing of payments. And so certainly at termination, if they owe you a lot of money, that's a harder situation than if you've negotiated that payments are going to be made on a monthly basis. So those are all things that kind of there are elements, various levers you can push that go hand in hand and make sure that you don't find yourself in a pickle if it doesn't work out.
One of the more frequent complaints that I've heard from expert witnesses is that occasionally it can be a little bit difficult to get paid, and you've mentioned this a little bit. What are some of the things that expert witnesses can do in these contracts to ensure that they are protected in situations where either the attorney is waiting for payment from the end client or they just haven't paid in a timely manner? What are the sorts of things that experts can do to add a little bit of a bulwark against that?
Well, that's an interesting question. And like all contract negotiations, it kind of comes down to what leverage you have. In some circumstances, you might be able to negotiate for some type of indemnification or payment obligation from the entity for whom you're providing the services, right? So if the end user is a law firm, maybe your contract is with the um, expert entity and that they're required to pay you regardless of whether or not the law firm pays them. That is something you can negotiate for. You can certainly imagine that the entity is looking for different terms. No one wants to be left holding the bag. But those are all things to at least be aware of as you're looking at these payment terms so that you understand what is your risk here in terms of whether or not you'll be paid.
Sometimes experts, and I would say even on balance, the majority of the time, experts aren't made aware when a case either goes to settlement or concludes in some fashion. They do their piece and then they move on. Should they be putting something in the contract so that they are informed or have some idea of the disposition of the case after their part is over?
It's an interesting question. I've not seen that, which doesn't mean that it shouldn't or is not in many of these contracts. I think that's an interesting idea. Um, I do worry that it would be one of those provisions that is in there, but maybe not always followed, only not for any nefarious reason, more because people forget. So if that is a concern for you, if you want to make sure you're not sort of drifting out there with no resolution, maybe think instead of that one obligation, think about an ongoing, you're required to check in with me on a monthly or quarterly basis to let me know the status of the case. And so that way there's something on the books, a reminder for everybody that we should be checking in.
In a contract between an expert witness and an attorney, there's kind of an inherent imbalance in the ability to enforce provisions because the expert is an expert in whatever their field is, but at the end of the day, the other party is an actual attorney. And so the best defense that experts have might be to know when to say no to a contract in the first place. Are there some common pitfalls or red flags that experts should be looking for in these contracts before signing in the first place?
As I think that through, I think anything that suggests that you're only paid if they're If, the attorney is successful in trial, right? The attorney might be working on a contingency basis, but you should not be paid for the success of your opinion, right? So
Sure.
anything that sort of triggers compensation to the end of the litigation where with a successful resolution, I think would be problematic. You want to be paid for the work product you've provided or the time you've spent. And so you really don't want to be in a position where you're waiting, where there's some type of delay in your compensation.
Often during depositions, these sorts of contract provisions are used to impeach expert witnesses. Are these contracts themselves discoverable?
It can be. I'm a recovering litigator, so I have not had to duke out one of these issues in a while. But I know in disputes I've handled in my past, we do look for any language that makes it sound like compensation is somehow triggered based on the opinion that you ultimately give. So you need to make it very clear that you're neutral. To my mind, this is more the obligation of the lawyer who ultimately wants to use you as an expert to make sure that, they're not requiring anything of you in their contracts that could be used to impeach your credibility rather than an obligation of the expert witness. But it's always good for you to be sensitive to those potential concerns.
When we began our discussion, we talked a little bit, or you mentioned a little bit, about the tax implications of being an independent contractor. And in fact, that might be why it's in many professions, an individual might be better off as a typical employee rather than a 1099. What are some of those tax and insurance considerations that experts should be thinking about before deciding whether or not they should be independent?
Well, I'll start with the tax consequences. So 1099 compensation is taxed differently than W-2 compensation. So we've already talked about some of the deductions that aren't made,
Sure.
but you tend to get more money up front. On the whole, I am not a tax expert. I'm not as familiar with the weeds of it, but in my experience in talking to people, on the whole, I get the impression that ultimately you still end up paying that money is still taxable income and you still pay taxes on it, but it's just at a different rate. And you also have the opportunity, as we mentioned, to write off some of your expenses. And so, my biggest recommendation for all of this is if you are i- pursuing independent contractor status, please work with a reputable accountant because these are the things that are subject to challenge, and you just wanna get it right.
And insurance considerations?
Oh, sorry. And then in terms of insurance considerations, often the contract itself will ask you to confirm your understanding that you're not getting health insurance, you're not getting any of the standard W-2 benefits, that, regular employees of the organization are entitled to receive, so you should be on the lookout for that. And then there might also be either an expectation that you either indemnify either the entity or the ultimate client of the services, or that you at minimum show that you're carrying sufficient levels of insurance. And these requirements might vary from contract to contract, but a good negotiator will be looking for some type of proof that, if the proverbial stuff hits the fan, that you are carrying sufficient general insurance to cover a potential problem. You do want to look at it, and you do want to look at if they're asking you to indemnify them for anything. I would be very weary and want to get a better understanding of what that really means, what that indemnification means. But um, sometimes you're looking to have them indemnify you. Sometimes they're looking to have you indemnify them. And these are all things you just have to, pay close attention to.
In terms of negotiating, is there any inherent difference in negotiating as an independent contractor? Are you at any inherent disadvantage or advantage, or does it depend more on what your specific expertise is that you're being hired for?
I think that's a great question. And my response would be, advantage and disadvantage is all in how you perceive the world, right? So one of the true values of being a contractor is you have a whole lot of freedom. You get to take on the projects you want to take on. If you get to work with the people you want to work with, you get to take on the subject matter you want to take on, you get to work at the rates you want to work at. So you have a lot of freedom. Most of your freedom is in terms of rejecting, right? So unless you are the ultimate superstar in your field, you might not. There are often more than one expert who could potentially provide that services. So if what you're looking for is an advantage in those negotiations, it's more in terms of what you can walk away from. But if you've got that particular niche, that expertise, and you know that you are the perfect person to handle this particular concern, use your knowledge.
Do you have any stories or cases that you can talk about, obviously without necessarily mentioning specifics, that illustrate any of these points about experts working in an independent contractor setting?
That's always the hardest question because of those privileges that we've been talking about. But what I would
Naturally.
say is not so much from a legal perspective, but just I think when you are a contractor providing these experts situations, you get the most interesting, the most exciting, the most cocktail story, cocktail party story stuff. And so it does keep your work, I think, more interesting, especially when you are in a situation where you can be a little more elective or selective with the cases that you're pursuing. You also get to be, work with people who really challenge, the right lawyers know how to use an expert to really become you remain independent, you remain neutral, but you become a member of the team in terms of making sure that the work you're provided is used in the best light possible.
Do you use expert witnesses in your own practice?
Well, as I mentioned, I'm a recovering litigator. So I have in the past, and I've cross-examined expert witnesses as well. But now at my stage, I do much more proactive counseling rather than litigating with expert witnesses.
Nevertheless, I'd like to ask you how expert witnesses get started on the right foot in general. What makes for a good expert attorney relationship?
Oh, that's interesting. So I thought you were when you started this question, I thought was going down a slightly different path, which I'm going to answer my question and then yours. But what I thought you were asking is, sort of like how do you find your way to the best, most interesting cases, and that really is in working with the best organizations to match you with those lawyers, right? So be selective in the expert witness organizations that you're working with. But then in terms of working well with the attorneys, I would remind you as much as you are on a team, it might feel like a team, you are a neutral and you're an expert, and the value you bring is that neutrality. And so you want to make sure sometimes, us lawyers kind of forget and are a little too colloquial or little too familiar with the experts. And I've always respected when there's some pushback there, right? Your role, you are not a member of the team. You are a neutral who's coming in to help support, provide your best understanding of the facts that are presented to you. But you are much more valuable when it is clear that that is the role you're serving, and that your opinions can't be bought, your perspective can't be bought. That you would provide the same answer no matter who is employing you.
I have one more question that I ask all of our guests. Do you have any preparation routines that you use to get ready for a big day, whether it's a trial, a deposition, any kind of big action? Not just the typical preparation. I like to read my notes and whatnot, but I've had guests come in that like to do yoga or listen to heavy metal or drink coffee or abstain from alcohol. Or do you have any specific thing that just kind of gets you in the right mindset, gets you ready to go?
To tackle today? Oh, I am a full-time attorney with 2 kids trying to make my way through the world. So my best preparation is a good night's sleep, and really it's about confidence, right? So If you start your day feeling like you've done everything you can to prepare for the day, then I'm going to have a good day. If I feel like I'm chasing one meeting to the next or one, conversation to the next, I feel like that's when I feel the most panicked and feel like I'm really not prepared for what's coming.
I love it. Before we wrap up, do you have any final advice for expert witnesses or attorneys working with experts for that matter?
My advice is, as I think that this conversation is important and a good reminder that you do need a contract in these situations. The number of times I've seen people proceed on handshake deals or sort of emails back and forth, or whatever document is provided to them, they just sign it and move on. These are contracts and they do have ramifications. And when all goes smoothly, you don't have to think about it. But, there are a lot of lawyers who have professions because things never go smoothly. So you should really just be thoughtful about the relationships you're entering into.
Absolutely sage advice. Ms. Campbell, thank you so much for joining me here today.
Thank you. I appreciate it.
And thank you, as always, to our listeners for joining us for another edition of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.